Well, I think the force of English precedent had declined very much even by the time I went to law school in the 1960s. Professor Boralaska, who was our constitutional law professor, regularly denounced the Privy Council and everything it had done. And in some areas of the law, contracts and torts, a lot of English cases were cited, but increasingly over the time I've practiced law, Canada looks at Australia, Canada looks at New Zealand, South Africa, other common law countries, and because we have a very strong civil law tradition in this country with Quebec, we also looked at what the commentators are saying in France and Belgium and so on. So I think the influence of England has greatly declined, and so when the Charter was brought into force in 1982, the lack of English precedent really was not a great consequence. What was interesting at the time was that the professors who traditionally have not been cited a great deal in Canadian courts, the judges here prefer to cite other judges, other courts, but because the Charter had some new aspects as well as its roots in the European Convention and so on, the academics achieved a considerable prominence and, if you will, filled a gap in the precedents with their own gathering of ideas and arguments. So I think that for the last 30 years, at least, Canada has been very independent of any other system, common law or otherwise. In the Charter cases, for example, police powers, we will almost always look at the United States law. This is because they've been at it longer than we have. And although we frequently disagree with the result they reach, we want to know what they say. A few months ago I was reading a New Zealand case where the court cited a Canadian case for the purpose of disagreeing with it. So citation doesn't always mean agreement. It simply means a recognition that some court somewhere has made an interesting observation which you may or may not agree with. But ultimately it's been a long time since Canada stood on its own feet. I think the influence is declining. I think the judges are aware of what the academics are writing. I think a lot of the ideas being thrown around by the academics make their way into the courtrooms through the lawyers and through lower court judgments. Some of the judges of the Supreme Court were themselves academic. They have a bit of a vested interest in maintaining the importance of what the academics talk about. But generally speaking, I think the influence of the academics is more and more through their students and through the law put forward by the students and picked up by the courts, as opposed to direct citation by the Supreme Court. Now there are exceptions. Peter Hogg is probably our leading constitutional scholar, and he will almost always be cited. Again, the court doesn't always agree with him, but we pay attention to what he said. Professor Clark in torts, and there are a number of academics who are listened to with greater enthusiasm than others.